Hello, dear future architects. Welcome to my channel. Let's continue reviewing the NCARB ARE 5.0 exams. In this video, we'll continue to review the ARE 5.0 Practice Management or PcM, and we are continuing with the section 1, which is the business operations. And in this video, we will take a look at objective 1.2, and that is all about applying the regulations and requirements governing the work environment. My name is Marina Ray. I am a licensed architect, and I have prepared this video series for you just to practice. So those are not the questions that you will see on the exam. These are just for you to go through the material and to train and to practice and to test your knowledge. So I have prepared 10 questions with the answers for you, and I will share my presentation with you. We'll go through that together, and then you will be able just to see what else may be asked at the exam. All right, so let's get started. All right, so I'm sharing my screen with you, and we'll go through the exam. Through just the practice questions, right? So before we do that, I always recommend to go to the NCARB guidelines, and you can find the most up-to-date guidelines on the ncarb.org website. And just you really need to get the most up-to-date version because they make changes, and you really need to stay relevant, and you need to be compliant with all the requirements. So please obtain the most up-to-date version from the website. Do not save the PDF because it may not be the one that you need. So as you know, division overview, let's just quickly go through that before we dive deeper into the questions. So the practice management division assesses objectives related to the management of architectural practice, including professional ethics, fiduciary responsibilities, and the regulations governing the practice of architecture. The division will focus on issues related to pre-contract tasks, including negotiation, human resource management, and consultant development. Candidates must demonstrate an understanding of and abilities in building business structure, business development, and asset development and protection. So the objective 1.2 actually talks about the regulations and requirements governing the work environment. So here you will need to demonstrate your understanding of laws, regulations, and insurance that will apply to running a practice, including health insurance, workers' compensation, general liability insurance, and labor laws. So let's talk a little bit about insurance, and that's our question number 1. So I will be reading the question together with the potential answers, and then I will review the correct answer, and we will see why, because I have provided a short explanation to this, to the answer and to the question. So the question number 1 is about health insurance continuation after termination. The question is as follows. An architecture firm with 12 employees is considering health insurance options. Which of the following federal laws requires the firm to provide continuation of health coverage to employees after termination under certain conditions? And the potential answers are as follows. A, ERISA, B, COBRA, C, FMLA, or D, OSHA. The correct answer is COBRA. And if you don't know these abbreviations, I highly recommend to take notes and just make sure that you really understand what's going on here. So ERISA is the Employment Retirement Income Security Act. COBRA is the Consolidated Omnibus Budget Reconciliation Act. FMLA is Family and Medical Leave Act. And OSHA is Occupational Safety and Health Administration, which is totally irrelevant to our insurance question. So here, the reason why we selected COBRA is because COBRA requires employers with 20 plus employees to allow continuation of health insurance after termination at the employee's cost. And ERISA governs retirement and benefits. FMLA covers unpaid family and medical leave, and OSHA addresses workplace safety. So let's go to the next question. And that's all about insurance here. Which of the following types of insurance protects an architectural practice if a delivery person slips and falls in the office reception area? A. General liability insurance. B. Professional liability insurance. C. Workers' compensation insurance. Or D. Employment practices liability insurance. The correct answer is the general liability. And the reason why is because it covers bodily injury and property damage to third parties, and those can be clients, visitors, or delivery personnel, not just the employees. That's the general liability. So we know that the professional liability, or E&O, or errors and omissions, covers design errors. Workers' comp, or workers' compensation insurance, covers employees, and employment practices liability covers discrimination or harassment claims. Sometimes you really need to read the question and read the answers, because sometimes the answer can be fabricated. It may not be the real thing, but it looks like it. So please always be cognizant, always look through all the things and just make sure that you follow the instructions, that you answer the question, not just something that you read between the lines. Let's go to the next one. Question number 3 is about the injury at work. An intern architect is injured while carrying materials on a construction site visit as a part of their job. Which insurance policy would most likely provide coverage for their medical treatment? A. General liability insurance. B. Professional liability insurance. C. Workers' compensation insurance. Or D. Health insurance only. So the correct answer is C. Workers' comp. And that covers employees' medical expenses and lost wages from work-related injuries. And we know that general liability protects against third-party claims. We just reviewed that in the previous question. And then professional liability, or errors and omissions, covers design negligence and some mistakes that may arise with the design and different types of conform documents. Health insurance applies to non-work related injuries. So that is what we have here. Let's go to the next question, and that is about OSHA. A firm is found to be in violation of OSHA requirements. Which of the following is OSHA's primary focus in regulating workplace environments? A. Fair wages and hours. B. Safe and healthy working conditions. C. Equal employment opportunities. Or D. Proper employee classification. So here the correct answer is B. Safe and healthy working conditions. And we know that OSHA enforces standards for workplace safety, such as ergonomics, hazards, PPE, or personal protection equipment, and site safety. And again, OSHA is the Occupational Safety and Health Administration. So just make sure that you know all the abbreviations, you know what they stand for, you know what they do, and then it will be easier for you to answer these types of questions. And again, these questions are not from the exam. These are just me helping you with your exam prep. Let's go to the next one, employment laws. Which of the following are typically covered under employment laws that architecture firms must comply with? A, overtime pay requirements. B, design copyright protections. C, family medical leave. Or D, professional liability insurance premiums. So here, there are two correct answers, and in your exam, you will be prompted to select a certain number of correct questions. It can be 2 questions or 3 questions or 4, and you will need to select all of them. And there is no partial credit. So if you selected 3 correctly and one of them is not, then the whole question will be marked wrong. So please remember that, and please make sure that you know how to do that, that you sometimes it's easier to select which is not included or what is wrong, and then that will eliminate those, and then you will see the correct answer. So here, the employment law actually um, cover the overtime pay requirements and family medical leave. So they are part of labor laws. And we know that FLSA covers overtime and FMLA covers family medical leave. So here, design copyrights are IP law, not labor law. Please remember that. And insurance premiums are a business decision, not a labor requirement. So these are the things that you need to know as the practice owner. So if you decide to open your own firm after you get licensed, these are the things that you really need to know. So don't treat these as just your exam questions. These are the fundamental pieces of information that you need to know to successfully run your architectural practice. So question number 6, coverage for design negligence. Which of the following insurance policies is designed to protect a firm against claims that its professional services were negligent or failed to meet the required standard of care? A, general liability insurance. B, workers' compensation insurance. C, professional liability or errors and omissions or E&O insurance. Or D, employment practices liability insurance. The correct answer is C, that's the E&O. And we know that the professional liability protects against claims of negligence, errors, or failure to meet standard of care in professional services. And again, general liability is accidents or property damage. Workers' comp is the employee injuries. And employment practices, it's HR-related claims. So they are not relevant to the claims when the architect or designer makes a mistake in the drawings or specification. That's the errors and omissions insurance that covers that. Let's go to question number 7, and that's the federal law. A small architecture practice has grown to 60 employees. Which federal law now applies that was not required when the firm had only 40 employees? A, Affordable Care Act. B, Family and Medical Leave Act. C, Consolidated Omnibus Budget Reconciliation Act. Or D, Fair Labor Standards Act. Here we're talking about FMLA, or Family and Medical Leave Act. And that applies to firms within 50 plus employees requiring up to 12 weeks unpaid leave for qualified family or medical reasons. So we know that the Affordable Care Act applies at 50 plus employees as well, but only for applicable large employers with full-time equivalents and focuses on health coverage, less directly tied to workplace regulations. COBRA applies at 20 plus employees, and Fair Labor Standards Act applies to any firm regardless of its size. So please remember those. So when the firm was 40 employees, FMLA was not applicable. But when the firm grew to 60 employees, now it is a completely different story. All right, let's go to our question number 8, and that's the workers' comp. So, which of the following is the primary purpose of workers' compensation insurance? A, to reimburse clients if drawings contains errors. B, to cover employee injuries and lost wages resulting from work-related accidents. C, to defend against claims of harassment or discrimination in the workplace. Or D, to provide property damage coverage for firm-owned equipment. The correct answer is to cover employee injuries and lost wages that resulted from work-related accidents. That's the workers' comp. And it's designed specifically for employees who are injured on the job. Other coverages protect clients, property, or professional services. So please remember that workers' comp is the injuries on the job. Let's go back to our types of insurance, and that's our question number 9. During a client meeting, an architect spills coffee on the client's laptop, damaging it. Which insurance would typically cover the cost of replacing the laptop? A, professional liability insurance. B, general liability insurance. C, workers' compensation insurance. Or D, health insurance. So here again, we're talking about the general liability insurance, and that's our question, that's our answer, B. So general liability covers property damage or bodily injury to third parties. Professional liability wouldn't apply. There is no design negligence. It's just an accident, that the architect spilled the coffee. And workers' comp is for employees. Health assurance is unrelated here as well. Let's go to our question number 10, and that is the final question. I only have 10 questions to share with you. But again, stay tuned. I will be recording the videos for all the divisions, all the sections. So it takes time, it takes some prep, but I am committed. So please let me know in the comments what else maybe you would like to get covered, and I will do my best to do that. And also, yes, subscribe to my channel, share the video, hit the like button and the bell so that you'll be the first ones to receive the update in the next videos. So question number 10 is about the health insurance. A firm with 30 employees offers group health insurance and contributes to employee premiums. An employee resigns and asks if they can continue coverage for themselves and their family for several months at their own cost. Which regulation applies and how must the firm respond? A, the firm must comply with COBRA, allowing the employee to continue coverage at their own expense. B, the firm must comply with OSHA, providing workplace accommodations. C, the firm must deny the request since coverage ends when employment ends. D, the firm must extend coverage indefinitely under FMLA. So here the correct answer is A. The firm must comply with COBRA. And again, COBRA is the Consolidated Omnibus Budget Reconciliation Act. And the reason why they should do that is because COBRA requires employers with 20 plus employees offering group health plans to allow coverage continuation after termination or resignation, usually 18 to 36 months at the employee's cost. And we know that OSHA covers safety. FMLA is for leave, no, not post-employment. And employers are not required to extend coverage indefinitely. So look for those kind of like fabricated answers. They may just confuse you. They're incorrect, but they are there just to, you know, look like it is something important, but actually it is just confusing. So that is it. Thank you so much. I appreciate you being here with me. I will continue recording the videos and I will share them as soon as they're ready. Please ask questions, leave comments, and like my video. Thank you so much, and I wish you the best of luck. You will get licensed in no time. Goodbye.